guys, it's Kathy. I hope you're doing well. Sorry I'm late. My phone overheated and shut off last night. Probably because it was under my stomach, but I can't be sure and we'll never know. But we got good court today.
Many of those charges. Mr. Pavlovsky.
State of Indiana is charging the defendant Zachary Shane O'Neill with 2 criminal counts. Count 1, intimidation, a level 6 felony. Officer Carlson of the Valparaiso Police Department swears under the penalty of perjury that on or about December 21st, 2025, in Porter County, Indiana, Zachary Shane O'Neill did knowingly or intentionally communicate a threat to victim 1 with the intent that victim 1 be placed in fear that the threat will be carried out, and a forcible felony, and was communicated to a law enforcement officer because of his or her occupation or profession contrary to Indiana code and against the peace and dignity of the state of Indiana. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections. Count 2, invasion of privacy, a Class A misdemeanor. Officer Carlson swears on the penalty of perjury that on or about December 21st, 2025, in Porter County, Indiana, Zachary Shane O'Neill did knowingly or intentionally violate a protective order issued to prevent domestic or family violence contrary to Indiana code and against the peace and dignity of the state of Indiana. A Class A misdemeanor is punishable by 0 to 365 days in the Porter County Jail. Those are the charges.
Mr. O'Neill, do you understand what the charges are that have been filed against you?
Yes, sir.
Do you understand what the potential penalties may be if you're convicted of either of those charges?
Yes, sir.
I'm entering not guilty pleas for you on both counts, reserving your right to a jury trial and ordering the state to produce discovery to you or your attorney. Let me advise you of your rights, because the highest charge in this matter is a level 6, and there's been level 6s and higher felonies before. So I'm going to advise you to make sure you understand.
YouTube is giving me a huge yellow error right now, saying the video is playing to me. Oh no. Okay, I'm back. I can't blame the cats because, oh no, YouTube is giving me the big yellow warning again. I fixed it. I think it's fine now. I can't blame the cats because there's only one cat down there. One. But somehow my cord way downstairs just came out a little bit. I'm blaming the cat. Well, it wasn't me. I wasn't down there. I was sleeping on my phone. All right, let's try this again.
Mr. Pavlovsky.
State of Indiana is charging the defendant Zachary Shane O'Neill with 2 criminal counts. Count 1, intimidation, a level 6 felony. Officer Carlson of the Valparaiso Police Department swears under the penalty of perjury that on or about December 21st, 2025, in Porter County, Indiana, Zachary Shane O'Neill did knowingly or intentionally communicate a threat to victim 1 with the intent that victim 1 be placed in fear that the threat will be carried out, and the threat was to commit a forcible felony and was communicated to a law enforcement officer because of his or her occupation or profession contrary to Indiana code and against the peace and dignity of the state of Indiana. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections. Count 2, invasion of privacy, a Class A misdemeanor. Officer Carlson swears on the penalty of perjury that on or about December 21st, 2025, in Porter County, Indiana, Zachary Shane O'Neill did knowingly or intentionally violate a protective order issued to prevent domestic or family violence contrary to Indiana code and against the peace and dignity of the state of Indiana. A Class A misdemeanor is punishable by 0 to 365 days in the Porter County Jail. Those are the charges.
Mr. O'Neill, do you understand what the charges are that have been filed against you?
Yes, sir.
Do you understand what the potential penalties may be if you're convicted of either of those charges?
Yes, sir.
I'm entering not guilty pleas for you on both counts, reserving your right to a jury trial and ordering the state to produce discovery to you or your attorney. Let me advise you of your rights because the highest charge in this matter is a level 6. And
If you can't see chat and you're watching this on replay, half the people lost sound, half the people didn't. If you don't have sound right now, refresh and you should have sound.
there's been level 6s and higher felonies before, so I'm going to advise you to make sure you understand. You have the right to a public and speedy trial. Do you understand that?
Yes.
Your trial could be conducted in front of 6 jurors or me. Do you understand that?
Yes.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You have the right to face and cross-examine every witness. Do you understand that?
Yes, sir.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes.
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
I do.
You have the right to an attorney. If you cannot afford one, I will appoint one for you at no charge. Do you understand that?
Yes.
All right. And I have already entered not guilty pleas for you, so we're now going to address bond. The prosecutor goes first. Mr. Pavlovsky.
Thank you, Judge. The pretrial service report scores the defendant a 4 moderate, showing no FTAs in the past 2 years. That being said, his criminal history in the state of Indiana shows this is the 11th criminal cause. I believe, fourth felony cause number. All priors were F6s as well. I would note that a number of the prior cause numbers contain violent offenses, battery, domestic battery, intimidation, resisting law enforcement, things of that nature, including a couple of OWIs. Obviously, based on the invasion of privacy, as reflected in the probable cause, there is a domestic battery case in LaPorte County as well. So I would argue that the defendant does pose a danger to the community, specifically to the listed victim under count 2 and count 1, frankly, the officer involved in the intimidation charge. I would ask that bond stand at $1,500.
Before we hear from Mr. Elwood, what's the status of the LaPorte County domestic case? Do you know, Mr. Pavlovsky?
One moment. So that he was sentenced back on March 3rd of this year. It appears that he's still on probation. There's a term of 540 days with jail credit of 420 days. But I don't show that the case has been closed out yet. So I'm not sure if there was probation violations or what was going on with that. I do see a petition revoked back in June, so he may still be on probation, but I can't tell for sure.
Mr. Elwood.
Judge, he scores a 4, moderate on the IRAS, no FTAs in the last 2 years. Lives locally. I would ask for an OR release supervision level 2.
Your Honor, may I please? I'm sorry.
You may.
I knew that something would come up with the timing and everything, but whether or not you believe me or if there is the proof, I can tell you exactly that this case happened in 2023. And my lawyer pushed the dates back all because he had so many cases. I never asked for it to be pushed back. So
Wait.
Yeah.
It's alleged in this case that on December 21, 2025, so it's alleged that 8 days ago, you were intimidating a law enforcement officer and a person with whom there was a no contact order, which is why there was an invasion of privacy. So it's not years ago, it's 8 days ago in Porter County, Indiana. Those are the allegations. We're not going to have a trial today, so you may be digging yourself a deeper hole, but you can tell me whatever you want and continue to dig.
Okay. I just, in regards to what happened with my last case is punishment, whether I'm still on probation, I just did the last charge that I had for that domestic previous was the date was in 2023, and it took a year for I might be digging myself.
I understand that. It sounds like you sat in jail for 400 and some days.
No, Your Honor. I'm not on probation. I was on GPS for 9 months, and I ended up getting that done this past year. The most recent charge that it shows was I was out of bounds on GPS, and I went.
All right.
They called me. I didn't have to get taken in. I went into my meeting, and they said I had, gone out of bounds.
I went in. That's something that may need to be taken care of in LaPorte County. We're not going to do that today, but we're going to do something similar today. I set bond for you in the amount of $1,500 cash. And if you post bond, you will once again be required to have an ankle monitor. And the out of bounds is you are not to be within 1.5 miles of the protected person. Do you understand that? Do you have the money to hire a lawyer, sir?
think I will be able to post bond and.
Okay.
And use that, I believe.
All right. So I'm setting dates as follows. January 26th at 10 o'clock for an attorney status conference date to see if you've been able to hire a lawyer. February 23rd at 10 o'clock for an omnibus change of plea hearing. April 13th at 10 o'clock for a final pretrial conference.
His lawyer that was helping him so far just got up and put his coat on.
And May 11 at 1 o'clock for jury selection. Did you hear those dates, sir?
Can you say it one more time, please?
January 26th at 10 for an attorney status conference. February 23 at 10 for an omnibus change of plea hearing. April 13th at 10 for a final pretrial conference. And May 11th at 1 o'clock for jury selection. And I believe the person seated to your left also wrote down those dates.
Thank you.
Mile and a half.
Delise Ross. This is State of Indiana versus Ross, cause number 64D02, 2512 F5 14033, state by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail. Is this yours, Patrick?
Yes, it is, sir.
Along with Attorney Young, who appears remotely as well. We are set for initial hearing.
Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
That's true.
What is your name?
Delise Ross,
How old are you?
36.
Do you understand English?
Yeah,
Are you under the influence of any drug or alcohol?
no,
Do you have any mental or emotional disability?
no,
If there's ever a time where you can't hear or understand anything at all for any reason, will you let me know, please?
yes,
Mr. Young, have you gone over the charges and penalties with your client?
Judge, I have not. I was,
All right.
haven't had the opportunity yet.
Ms. Ross, the prosecutor will advise you of the charges and penalties that have been filed against you in this matter.
okay,
State of Indiana is charging the defendant with 6 criminal counts. Count 1, criminal recklessness, a level 5 felony. Detective Nichols of the Portage Police Department swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December, 2025, in the county of Porter, state of Indiana, Delise Marie Ross recklessly, knowingly, or intentionally performed an act that created a substantial risk of bodily injury to another person, and the offense was committed by shooting a firearm into an occupied motor vehicle, to wit, the defendant shot a firearm into the vehicle operated by Josephine Lopez, contrary to Indiana code and against the peace and dignity of the state of Indiana. Count 2, criminal recklessness, a level 5 felony. Detective Nichols swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December, 2025, in the county of Porter, state of Indiana, Delise Marie Ross recklessly, knowingly, or intentionally performed an act that created a substantial risk of bodily injury to another person, and the offense was committed by shooting a firearm into an occupied motor vehicle, to wit, the defendant shot a firearm into a vehicle occupied by an individual with the initials AL with a date of birth of August 9th, 2018, contrary to Indiana code and against the peace and dignity of the state of Indiana. Count 3, criminal recklessness, a level 5 felony. Detective Nichols swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December, 2025, in the county of Porter, state of Indiana, Delise Marie Ross recklessly, knowingly, or intentionally performed an act that created a substantial risk of bodily injury to another person, and the offense was committed by shooting a firearm into an occupied motor vehicle, to wit, the defendant shot a firearm into the vehicle occupied by an individual with the initials JL, date of birth July 26, 2013, contrary to Indiana code and against the peace and dignity of the state of Indiana. Each level 5 felony is punishable by 1 to 6 years in the Indiana Department of Corrections. Count 4, pointing a firearm, a level 6 felony. Detective Nichols swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December 2025 in the county of Porter, state of Indiana, Delise Marie Ross knowingly or intentionally pointed a firearm at another person, contrary to Indiana code and against the peace and dignity of the state of Indiana. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections. Count 5, unlawful carrying of a handgun, a Class A misdemeanor. Detective Nichols swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December 2025 in the county of Porter, state of Indiana, Delise Marie Ross did knowingly or intentionally carry a handgun, to wit, a Glock 9mm handgun with a serial number of AHAL114, while having a pending formal accusation of a crime made by a prosecuting attorney in any court for a crime punishable by a term of imprisonment exceeding 1 year. To wit, the defendant was charged with domestic battery in the presence of a child as a level 6 felony on December 30th, 2024, under cause number 64 DO6 2412 F6 13277. And this matter was pending at the time of the instant allegations, contrary to Indiana code and against the peace and dignity of the state of Indiana. And finally, count 6, invasion of privacy, a Class A misdemeanor. Detective Nichols swears on the penalty of perjury that the following representation is true, that on or about the 25th day of December 2025 in the county of Porter, state of Indiana, Delise Marie Ross knowingly or intentionally violated a no-contact order issued as a condition of pretrial release, including a release on bail or personal recognizance. To wit, the defendant had contact with a protected person, Anissa Ross, in violation of the no-contact order issued on December 30th, 2024 by Judge Jeffrey Tody under cause number 64 DO6 2412 F6 13277, contrary to Indiana code and against the peace and dignity of the state of Indiana. Each Class A misdemeanor is punishable by 0 to 365 days in the Porter County Jail. Those are the charges.
Ms. Ross, do you understand what the charges are that have been filed against you in this case? Do you understand what the potential penalties may be if you're convicted of any of the 6 charges in this case?
Yes.
The judge is mad.
You have the following constitutional rights. You have the right to a public and speedy trial. Do you understand that?
Yes.
Your trial may be conducted in front of 12 jurors or me. Do you understand that?
Yes.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to face and cross-examine every witness. Do you understand that?
Yes.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes.
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
Yes.
You have the right to an attorney, and I understand that Mr. Young represents you in this matter, but if you cannot afford one, I will appoint one for you at no charge. Do you understand that?
Yes, I do.
I am entering not guilty pleas for you on each of the counts, reserving your right to a jury trial and ordering the state to produce discovery, including your criminal history, to Mr. Young. Before we address bond, though, I want to say this. I understand that there is a level 6 case that's currently pending in Judge Tody's court.
Yeah.
Based upon the Porter County local rules and given the jurisdictions of his court and my court, that matter will be transferred to this court. So I will have this level 5 case as well as Judge Tody's level 6 case. We've attempted to communicate with Judge Tody's office today, but it is a holiday. So, but I understand as well that there's a petition to revoke bond that has been filed in that matter. But again, it hasn't been transferred yet. But as soon as Judge Tody gets in the office and sees it pursuant to the local rules, it will be transferred. So the plan will be this, Ms. Ross, is that as soon as Judge Tody sees the petition to revoke, he will act upon that. And then once he does so, then the case will be transferred to me. So I will have both the level 6 case that's pending in front of him temporarily, as well as this case. Do you understand that?
I understand.
Mr. Pavlovsky, we're not going to address bond. And before that, the defendant has signed 3 additional no contact orders with JR, Arissa, and Josephine. Did you sign no contact orders in the jail, Ms. Ross?
Yes,
And you understand that you're to have no contact in person or by social media or any communication at all with those protected people. Do you understand that?
yes, I understand.
Mr. Pavlovsky?
Thank you, Judge. I don't have a pretrial service report. I don't know if one was completed. But I did look at the DO6 cause number. I didn't see any failures to appear. Under that cause number, I believe she lives in Portage, so I don't think there's necessarily a flight risk present. However, based on the nature of these charges in combination with the pending F6, that wasn't Judge Tody's court that's being transferred. I believe she certainly poses a danger to the community, specifically the list of victims and the charging information. I did see that she is being held no bond in the DO6 case based on the state's motion until at least January 7th, when that matter was set for a bail review hearing. I would ask the court to adopt that order and hold the defendant no bond until the omnibus date or a bail review date, whatever the next date is in this cause number. In addition to that, I would ask that bond be set at $20,000 cash under the F5.
Mr. Young?
Judge, I would ask the court to consider setting Ms. Ross a bond today. In support of that, I would say, number one, she is a Porter County resident. She has no criminal activity that I see recently, other than these 2 cases that are pending before the court. Again, she resides in Porter County. She has 4 young children that need to be provided and cared for. They range in age up to 16 years of age, and she does need to be there with them. In addition to that, Judge, she is gainfully employed as a assistant manager at the Sunoco gas station in Valpo. Her job is still available to her. Victim in the F6 case, I've had communication with her, happens to be her mother, and I'm quite confident that case will be resolved favorably and to the defendant's benefit. She has no failures to appear. She has no recent criminal activity. The only thing I could see is a case back in 2017 that is a Lake County case that I represented her on that was resolved favorably. She's, I don't believe, a flight risk. She has no contact orders that are in place for the alleged victims here. She will have no contact with them. She'll abide by those orders. I would ask the court, based on the circumstances, mainly her children, that she be given a bond and that we be given as soon as court date as possible to address these matters.
So we're going to address dates first, and then I will set bond, and then we'll set sort of a bail review date based on what Judge Tody has done once it's transferred in. But Mr. Pavlovsky, what page in the probable cause affidavit does it refer to the car's radiator? Do you know? Or also refer to a car smoking at some point? Is that in this one?
One moment.
Well, I'm gonna address the allegations, and I've just heard that Ms. Ross should be released from jail, to care for her young children, ages 16 and below. It's alleged in this case that Ms. Ross fired a gun into a car that was occupied by an adult and two young children. It's alleged that that bullet was either fired into the air and then miraculously struck a radiator on a car, which is dangerous to occupants in the car, could have killed any of the three. It's not charged as an attempted murder case. It's charged as a criminal recklessness case. Does the probable cause affidavit make reference to the radiator or smoking car, Mr. Pavlovsky?
It's in the middle of page 8 of the charging information. And for the record, since the court made a reference to it when the police department submitted these charges to our office, it was originally recommended to be charged as a level 1 attempted murder. However, upon review of the charges, the state chose to file it as it's currently filed.
And I understand that there's a mens rea element without getting into specifics of charging. But regardless of the specifics of charging, it's incredibly dangerous to all people, including kids who are sitting in a car. Bond is set in this matter in the amount of $250,000 cash. And I understand that there's a bail review hearing set that Judge Tody set. And what Mr. Young has asked for is that we have a bail review hearing in this case as soon as possible because his client is employed and is a mother. So the bail review date that Judge Tody's office set, when is that set right now, Mr. Young? Do you know?
January
7.
7 at 1 o'clock, I think.
All right. This. All right. Are you available, Mr. Young, January 7th at 9 o'clock? You may attend by Zoom, sir.
Yes.
Bond is set in the amount of $250,000 cash. The no contact orders that were previously signed remain in force. If the matter is transferred from Judge Tody, which we anticipate that it will, the bond review hearing that he had set January 7th at 1 will now be set January 7th at 9 o'clock. Ms. Ross. All right. I will see you January 7th at 9 o'clock.
Thank you.
Thank
Judge.
you.
Are we setting omnibus and trial dates on the newer cause, or?
We are, and thank you, Mr. Pavlovsky. The following dates are also set. February 18th at 10 o'clock for an omnibus change of plea hearing. April 8th at 10 o'clock for a final pretrial conference, and May 11th at 1 o'clock for jury selection. If we need to tweak or move those dates at all based upon Mr. Young's calendar, we will do that January 7th at 9 o'clock. That will be all.
Thank you, Judge.
Thank you, Mr. Young.
Hi, Bev.
We're going to deal with this today, whether you want to or not. We're going to deal with it today. We're going to get this process moving forward. You've indicated you've appeared under some term that I'm not familiar with.
In pro per. She is not pro se. She is in pro per. That's the term. She said, this is a sound sit. Unfortunately, we can't hear her because she's not close enough to the mic. She won't come closer. But we hear what she says as the judge repeats it back.
So is it your position that
Well, that's awkward. I did that. And I recorded myself doing that.
well, I've been advised she's
Sorry.
not representing herself pro se. She's representing herself by a way of pro per. Okay, I'm not familiar with that term. All right, Ms. Boros, if you can explain to me what that term is and what it means. No. All right, well, Ms. Boros, let me explain something to you here real quickly. You're here for arraignment on a criminal matter. And we're gonna deal with this today, whether you want to or not. We're gonna deal with it today. We're gonna get this process moving forward. You've indicated you've appeared under some term that I'm not familiar with. So is it your position that you're not going to enter a formal plea of guilty or not guilty? Mr. Haverco is the court appointed counsel. I can't answer any questions. So I'm going to ask you if you have any questions, if you want to take a minute and talk with Mr. Haverco, that would be fantastic. Did you want to, doesn't have any priors? Reduce it down to 150. Good with that? Okay, you just go let the clerk know, and if we need to sign anything, we'll do it. Oh, criminal. Okay, yep, good luck to you. Criminal. All right, Mr. Haverco.
So I don't know what's going on with YouTube today. I'm sorry, but it's throwing up error after error. I am connected fine, but it is saying that the video is just buffering for you guys. Is anybody getting a lot of buffering? It looks fine on my side, but it just stopped there for a second. I'm just going to press play. It doesn't sound like you guys are complaining about buffering. They are costly. They absolutely are. Living is costly. Everything's perfect. Excellent. Now it says this. Everything is excellent. Maybe I just needed to stop the video for a second and let YouTube catch up with itself. Oh, wait. As soon as I said that, it can't be ads every minute. I have it as low as possible. If you're getting ads, you don't want to see ads, use your Prime, Amazon Prime account to sub to Twitch, to my Twitch channel. That's free. You just use your Amazon Prime, sub to Twitch, and you can watch there with no ads. I'm not asking you to do that. It doesn't make a difference to me. I'm just saying you don't want to see ads.
Does she have any more questions for you? Something about right to travel. She wasn't driving. Okay. Right to travel. Okay. All right. Do we have rights form? Do you have a rights form? I can think. Okay, why don't you pull that up? All right, Ms. Boros, I'm going to go over a couple things procedurally. So first of all, I'm going to advise you of your constitutional rights. This is again cause number, this is a criminal matter under cause number 5809490022. You're charged with a criminal offense that carries a possible jail sentence. You understand you have the following rights. Whether you agree with them or not, I'm going to read them to you. You have the right to be represented by an attorney of your choosing at all proceedings. If after I am screened, it is determined that I cannot afford an attorney, one will be appointed to me. Even if I do not have an attorney at arraignment, I do not waive my right to an attorney at any later proceeding. I am presumed innocent of any charge until the charge is proven beyond a reasonable doubt. I have a right to a speedy trial. If I'm held in jail before trial, I must be brought to trial within 60 days after the date of my arraignment, or if I'm released from jail and you are out of custody, so the amount of time would be 90 days after the date of your arraignment. That 90 days would start today. I have a constitutional right to a jury trial unless I specifically give up that right by signing a jury trial waiver. If I waive my right to a jury trial at arraignment, I have 10 days to change my mind and request a jury trial. I have the right to see and hear and question all witnesses who testify against me. I have the right to call witnesses on my behalf. I may have the court subpoena witnesses to appear and to testify at no prior expense to me. I have the right to testify on my own behalf. I also have the right to remain silent and not give testimony or present any evidence in my defense. My silence cannot be used against me. If I feel I cannot have a fair trial because of the bias or prejudice of a particular judge, I have a right to ask for a different judge within 10 days of actual notice of assignment to that judge. I'm only entitled to one change of judge. I have the right to appeal from any finding of guilty following a trial by jury or judge. To begin the appeal, I must file a written notice of appeal in this court within 30 days of judgment. If I plead guilty, I give up or waive all of the rights listed above, except the right of representation by an attorney, unless I assign a written waiver of my right to an attorney. If I am not a U.S. citizen, a conviction of a crime may result in deportation or exclusion from admission to the United States or denial of naturalization. I understand I have the right to consult with an immigration attorney prior to being arraigned. I've read the above rights, or I understand those rights, or I've had those rights read to me. Ms. Boros, you're present in the courtroom. Were you present when I read you those rights? Okay. I'm going to again defer to Mr. Haverco as your counsel to answer any questions you have. And Ms. Burrows, I'm going to stop you. What I'm going to do is what I do with folks that have arguments of that case, of that situation. I'm going to have you submit it in writing in the form of a motion. If you have a motion at a later time, I'll have you submit it to the clerk's office. Then I'll get it so I can read it ahead of time. All we're dealing with today is an arraignment, which is a procedural process. So I'm gonna, if you're not going to enter a plea, I'm going to enter a plea on your behalf, which is going to be a plea of not guilty to the charge. What we're going to do is we're going to set this matter for a pretrial, unrepresented pretrial, as it relates to the two criminal matters, and then the infractions. Ms. Burrows can deal with those as she sees fit. So I'll need an out of custody. You're going to be released under the following conditions, Ms. Burrows. Those conditions are going to be law-abiding behavior, and you're not to drive without a valid license and liability insurance. So they're pretty straightforward conditions. And next court date is going to be January. That's not right. Okay. Next court date, Ms. Burrows, is going to be February 12th. At that time, as of right now, you're not represented, so you'll be representing yourself. I'll go over some additional conditions that are discussed at that time relating to somebody that moves forward representing yourself. You're going to be held to a same standard I would hold Mr. Haverco or Mr. Ratfield to. But again, any objection you have to process, any objection you have to jurisdiction, I ask you to file that in writing with the clerk, and then I'll review it ahead of time. Next court date's going to be February 12th, 2026 at 9 a.m. You'll be given a copy at the window out to your left. All right? Thank you very much.
And do you want to just use the paperwork and then scan it in?
I'm happy to look at the paper. This is 25 CR 1621, People versus Donovan Wilson.
Kim Flynn on behalf of the people.
Your Honor, Chris Braddock, Appearance Counsel for Mr. Wilson. He is present. We've reached a resolution. Mr. Wilson, we're pleading guilty to an added count. It'd be an M1 menacing. We have a stipulated sentence of probation with the only condition being 1 day of jail. That would be concurrent to his current sentence, 23 CR 2790. I did have a brief record to make on another matter that's not up. It's 22 CR 3036. Is that right?
Correct.
Yeah, 22 CR 3036. That case is currently on appeal. And so I know the court doesn't have jurisdiction, but I just wanted to let the court know that in my review of that case, it appears that Mr. Wilson's bond when he was sentenced to prison probably should have been revoked at that point in time. And so the time that he has now on that 22 case should, by my calculations, it should be already over the 18 months, which is the max DOC sentence that we have. Initially, he was on probation on that matter. That probation was well, it went up on appeal, but then he picked up the 2790 case, which he's currently in DOC for. And so, but I don't believe it's affecting his time in DOC, but I'm just not understanding why we're messing with it and why, because once the appeal comes back, we're gonna have to bring him back, and at the same time, the case will probably just be deemed completed. But anyway, I wanted to bring that to, I know it's not necessarily on the court's docket today, but I think it's something that is bothering Mr. Wilson, and just to let the court know about that.
All right, the 22 CR 3036 is on appeal. Looks like a petition for cert was filed on December 18, 2025, based on the Court of Appeals opinion. I don't have jurisdiction. Ms. Fulham.
Well, I just turn the ads off. If YouTube is going to be a pain in the ass today, they don't need to get ads.
First addressing the case that is docketed today, the 25 CR 1621. Counsel did represent the plea agreement correctly. I don't believe we need to put him on probation. It could just be sentenced to 1 day jail. I think it would be.
That's fine.
I don't think there would be any merit to doing that. As far as the 22 CR case, I would suggest that counsel just file a motion in that case if he has some concerns and docket it. And then if the court has jurisdiction, we can look at it. But at this point, it is on appeal. So I'm not prepared to address it.
I don't think I can do anything with it.
Okay.
Let's talk 25 CR 1621. Mr. Wilson, we're going to have a conversation about what the lawyers just told me. If you would speak right into that microphone, start by saying your first and last names.
Good morning. My name is Donovan Wilson.
Are you the defendant charged in this case?
Unfortunately, I am.
How old are you?
37.
How far have you gone in school?
I'm still in college.
Are you thinking clearly today?
I'm thinking all right, sir.
Do you
Yes.
read and understand the English language?
That I do.
Are you under the influence of any street drugs or alcohol?
No, sir.
Have you consumed any pill, drug, or alcohol in the past 24 hours?
I have not.
Do you suffer from any mental or emotional condition that makes it difficult for you to understand what's happening in court today?
I understand what's happening in court today.
You don't suffer from any condition that makes it difficult for you to do that?
don't suffer from I'm not a doctor, but I don't think I suffer from anything of that.
The disposition, as I understand it, is you would plead guilty to added count 3 menacing. That's a class 1 misdemeanor. You'd be sentenced to 1 day in the Denver County Jail. Is that your understanding of the disposition?
Excuse me, one more time, because it was kind of fast.
Yep, you'd be pleading guilty to added count 3 menacing. That's a class 1 misdemeanor. You'd be sentenced to 1 day in the Denver County Jail. Is that your understanding of the disposition?
I understand that.
Is that how you want to proceed today?
I want to proceed with that.
Have you had enough time to discuss this with Mr. Braddock?
Mr. Braddock has came and talked to me, yes.
Are you satisfied with his representation?
I'm satisfied with Mr. Braddock's representation.
Added count 3 says menacing, class 1 misdemeanor. On March 23rd, 2025, by any threat or physical action, unlawfully and knowingly placed or attempted to place Israel E. Brewer in fear of imminent serious bodily injury in violation of the law. With respect to added count 3, what is your plea? Guilty or not guilty?
Sorry, one more time.
With respect to added count 3, how do you plead today? Guilty or not guilty?
I'm going to say guilty.
Are you a member of or veteran of the United States Armed Forces?
Veteran of the United States Marine Corps.
When did you serve in the Marine Corps?
June 4th, 2007 to June 4th, 2009.
Are you aware that there are certain services and benefits that may be available to you through the Veterans Administration?
Kind of, sure. I heard of him.
There's a card that I can give you that may provide some more information. Would you like that card?
Thank you.
Thank you. Before I can accept your plea, I need
I think he assaulted someone else. I think. I don't know though.
to make sure you understand certain rights that you have and the effect of your guilty plea on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case, up to and including trial. If you were indigent, if you could not afford an attorney, one would be appointed for you by the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offense beyond a reasonable doubt to a unanimous jury of 12. At trial, you'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
Yes, sir.
Do you understand that by pleading guilty today, you give up all those rights? There will not be a trial.
Yes, sir.
The lawyers have given me several documents. The first one is captioned Request to Plead Guilty, Rule 11 Advisement Misdemeanor, 4 pages long. It has the initials DBW along the sides of pages 1 through 3, a signature above the line for your name, today's date, January 2nd, 2026, at the bottom of page 4. Are those your initials and signature?
That is mine.
Did you have a chance to review this with Mr. Braddock?
We talked about it.
That you had about it?
I was able to ask him some questions.
Was he able to answer those questions?
Mr. Braddock answered the questions.
By initialing, signing, and dating this document, does that mean you read and understood what it says?
Well, we went over it, but I didn't have to read it.
Do you understand what the document says?
I understand what it says.
The second document captioned Elements Menacing, Class 1 Misdemeanor. Your signature above the line for your name, today's date, January 2nd, 2026 at the bottom. Did you have a chance to review this with Mr. Braddock?
I reviewed that paper.
Were you able to ask him any questions that you had about it?
Told me I'm going to get a misdemeanor.
Were you able to ask him any other questions that you had about the document?
Is it going to affect my me getting out of prison sooner?
Let me ask this a different way. I'm not asking what questions you asked him. I'm asking if you had the opportunity to ask him questions.
I asked him questions.
Was he able to answer those questions?
He was able to answer those questions.
By signing and dating this document, does that mean you read and understood what it says?
It does.
Do you admit that you committed the offense listed in the elements? And are you waiving the requirement of the district attorney to prove those elements beyond a
If you can hear this one moment, guys.
reasonable doubt to a unanimous jury of 12?
Yes.
In signing both these documents, do you understand you're waiving any defenses you may have had to this charge?
I'm gonna take a plea deal.
Do you understand you're waiving any defenses that you may have had?
I understand that.
You're subject to certain penalties as provided by law. For the class 1 misdemeanor, you could be sentenced to up to 364 days in the county jail, a fine of $1,000. I understand you have an agreement to 1 day, so we're not talking about anything more than that. But I want you to understand those are the maximum possible penalties for this offense. Do you understand that?
$5,000 fine.
$1,000 fine. That's the
Oh.
maximum, but we're not talking about that in this case. That's just the maximum penalty range.
So my maximum penalty is $5,000.
It's what you can get on,
Oh yeah, that's mine, right?
yeah, so that's.
Oh, all right,
Does that all make sense?
makes sense.
Other than the disposition we've discussed, have any other promises been made to you to get you to plead guilty?
I don't think any other promises was made to me.
Is anyone forcing you, or
Nobody's forcing me.
is your decision to plead guilty your own free and voluntary decision?
This is me and my attorney's will right here.
Factual basis.
We waive.
Do you have questions for me about your plea?
No, I just want to make sure I get the right help so I don't got to keep coming back to the jail or coming back in the courtroom.
Okay, so we done.
Any other questions about the plea agreement that we've been discussing?
Just hope I do well.
Is this still what you want to do?
Sure.
Anything else on the plea for the people?
Not from the people, Your Honor.
Mr. Braddock on the plea?
No, Your Honor, thank you.
I will accept your plea, make written findings. It is entered knowingly, intelligently, and voluntarily. Judgment of conviction enters on added count 3. Counts 1 and 2 are dismissed. What would you like to do on sentencing today?
The people are ready to proceed today.
We're ready to proceed also, Judge.
Waive PSI.
We do.
Defense does also.
Mr. Wilson, what I'd like to do is first I'll hear from Ms. Falone, then I'll hear from Mr. Braddock. I'll give you the last word if you'd like to say anything.
All right.
Ms. Falone.
Your Honor, I believe this is an appropriate plea agreement. This case involved some paintbrushes, which the victim in the case was attempting to sell. Defendant invited him to come to this trunk to get cash for the items. And the victim told the police on body-worn camera that the defendant pulled out a pellet gun and robbed him and took the paintbrushes from him without his consent. All those items were recovered and returned to the victim. The victim in the case originally was talked to about a misdemeanor resolution and agreed, but we haven't spoken to him recently. A consent to search of the car police did recover a pellet gun. Mr. Donovan gave consent for search of the car, and they did find the weapon.
Is there restitution?
No restitutions being requested because all the items were returned to the victim.
We'll find no pecuniary loss, order no restitution. Mr. Braddock.
Your Honor, very briefly, Mr. Wilson is currently serving another sentence in DOC. And he's got one sentence, I guess, or one case currently up on appeal. In this case, his car was seized and sold out from underneath him. He lost his car, lost property inside the car. Obviously, that was part of, and he lost some of his money, was seized also with the car itself. He is accepting this plea agreement and wishes the court to accept it.
Thank you. Mr. Wilson, you don't have to say anything. I am happy to listen to whatever you'd like to tell me.
I would like to wish I could move around in a different neighborhood and do, something different for myself and hang around anybody that could cause me harm. So I just want to do better.
Timer stop.
I appreciate that. Thank you. Here I will follow the agreement of the parties on added count 3, the class 1 misdemeanor. I will send you to 1 day in the Denver County Jail. There is no fine. We'll impose statutory costs and fees. Turning to the mandatory protection order that was entered on March 24th, 2025, what's the people's position?
The people's position is with the 1 day credit for time served. There will be no further time on his sentence, and we're fine with vacating the protective order.
The mandatory protection order entered on March 24, 2025 is vacated. That means, Mr. Wilson, that there's no more protection order in this case. I don't know about any other case, but in this case, there is no mandatory protection order.
All right.
What else can we talk about on sentencing today?
Nothing, Your Honor. So special offenders.
With this, I don't need to take any action on the DOC detainer. Is that correct?
I'm sorry?
With this resolution, I don't need to take any action on the December 29, 2025 DOC detainer.
No, I believe that will be resolved.
What else for the people?
Nothing from the people, Your Honor.
Mr. Wilson, good luck to you, sir.
Thank you.
Thank you.
Go to back. Same to you. Happy New Year.
So Brewer's not.
Actually, before we walk away from that, was there credit? That I
Yes, Your Honor.
We're just giving credit for 1 day.
Credit for
I
credit
do.
for 1 day. Mr. McCall is actually Mr. Burton. Since you've walked in, did Miss see?
He actually, when I was watching that, he actually made me nervous because he was such a character with his answers. I was way wrong, so every time he answered, I cringed. I was like, oh no, here we go. And he got to the end of the question and answered correctly.
What is in the computer? The disposition is?
And I should say, Your Honor, Jake Friedberg and Kate Horton on behalf of the people. Proposed dispositions, the defendant would plead guilty to an added count number 29. That would be attempted murder in the second degree, class 3 felony that names all 10 of the original named victims from the original counts. There's a stipulation to a sentence in the Department of Corrections with a range of 16 to 22 years. and a stipulation of liability with regard to all originally charged counts and originally charged victims.
Is that correct, Mr. Pello?
That is, Your Honor.
Mr. Ramirez, we're going to have a conversation about what the lawyers just told me. If you would step right up to that microphone, start by saying your first and last names.
Luis Ramirez.
Are you the defendant charged in this case?
I am
How old are you?
39
How far have you in school?
to the 12th grade.
Are you thinking clearly today?
I am.
Are you under the influence of any street drugs or alcohol?
No.
Have you consumed any pill, drug, or alcohol in the past 24 hours?
No.
Do you suffer from any mental or emotional condition that makes it difficult for you to understand what's happening in court today?
No.
The disposition, as I understand it, is you would plead guilty to an added count 29, which is criminal attempt to commit murder in the second degree. That's a class 3 felony. The added count 29 lists all of the original victims. There is an agreement that you would be sentenced to the Department of Corrections within the range of 16 to 22 years.
What you just missed during that little internet blip. I don't know what's going on with YouTube. I just don't know. 16 to 22 years. That's his range of attempted murder on 10 people.
You are agreeing to pay restitution for all charged counts, including those that are dismissed pursuant to this plea disposition. Is that your understanding of the resolution here today?
Yes.
Is that how you want to proceed?
Yes.
Have you had enough time to discuss this?
I have.
Are you satisfied with their representation?
Yes.
Added count 29 says criminal attempt to commit murder in the second degree, class 3 felony on October 14, 2019 by engaging in conduct constituting a substantial step toward the commission of murder in the second degree. Luis H. Ramirez unlawfully, feloniously, and knowingly attempted to cause the death of Savel L. Hassan, Jesse A. Mack, Miguel R. Madrelas, Mark A. Sanchez, Michael A. Stern, Carlos A. Sanchez Torres, Mohamed A. Growe, and Kendall R. Duckworth in violation of the law. With respect to added count 29, what is your plea, guilty or not guilty?
Guilty.
Are you a member of or veteran of the United States Armed Forces?
No.
Before I can accept your plea, I need to make sure you understand certain rights that you have and the effect of your guilty plea on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case, up to and including trial. If you were indigent, if you could not afford an attorney, one would be appointed for you by the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offenses beyond a reasonable doubt to a unanimous jury of 12. At trial, you'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
Yes.
If you understand that by pleading guilty today, you give up all those rights, the trial scheduled to begin on January 20th will not happen.
Yes.
The lawyers have given me several documents. The first one is captioned. The defendant's request to plead guilty, Crim P. Rule 11, guilty plea advice at the bottom of page 10. Are those your initials and signature?
Yes.
Did you have a chance to review this document with your attorneys?
Yes.
Were you able to ask them any questions you had about it?
Yes.
Were they able to answer those questions?
Yes.
By initialing, signing, and dating this document, does that mean you read and understood what it says?
Yes, sir.
The second two documents I've been given, captioned element and definition, criminal attempt, elements, murder in the second degree, class 2 felony. Both have a signature above the line for your name. the date of December 31 and December 30, 2025 at the bottom of each page. Did you have a chance to review these two documents with your attorneys?
Yes,
Were you able to ask them any questions you had about them?
yes,
Were they able to answer those questions?
yes,
By signing and dating these documents, does that mean you read and understood what they say?
yes,
Do you admit that you committed the offense listed in the elements, and are you waiving the requirement of the district attorney to prove those elements beyond a reasonable doubt to a unanimous jury of 12?
yes,
In signing all three of these documents, do you understand you're waiving any defenses you may have had to this charge?
yes,
You're subject to certain penalties as provided by law for the Class 3 felony.
Judge, that sentencing range would be 10 to 32 normally, which we have advised Mr. Ramirez about. I'm sorry to interrupt the court. I wanted to correct one thing. The initials in the blanks are actually LR. The court said LP, but those are Mr. Ramirez's initials.
I apologize, Mr. Ramirez. The initials, I misspoke. They say LR along the sides of pages 1 through 7,
yes,
which are your initials.
right,
Thank you, Mr. Pello. This is an extraordinary risk crime.
Yes, Your Honor.
You are subject to certain penalties as provided by law. You could be sentenced to between 10 and 32 years in the Department of Corrections, 3 years of mandatory parole, a fine of $3,000 to $750,000. I understand you have an agreement to a certain range, and that range is between 16 and 22. But that's the maximum possible penalty for this particular offense. Do you understand that?
yes.
Other than the disposition we've discussed, have any other promises been made to you to get you to plead guilty?
No.
Is anyone forcing you or pressuring you into pleading guilty today?
No.
Is your decision to plead guilty your own free and voluntary decision?
Yes.
As to factual basis,
We would waive the establishment of a factual basis, Your Honor.
do you have questions for me about your plea?
No.
Is this still what you want to do?
Yes.
I'll note the court's file reflects Rule 5 advisement. Anything further on the plea, Mr. Friedberg?
No, thank you.
Anything further on the plea?
No, Your Honor, not on the plea.
I will accept your plea, make written findings. It is entered knowingly, intelligently, and voluntarily. Judgment of conviction enters on count 29. Counts 1 through 28 are dismissed. What would you like to do with sentencing?
Judge, we're asking to waive PSIR, and for VRA purposes, Mr. Freeberg can't go to immediate sentencing, but we're going to ask to set it over until Thursday if the court can accommodate us at that time.
That is correct, Your Honor. There are a number of witnesses or of victims that are contemplating being present either in person or virtually and are contemplating addressing the court. This is a complicated case. Obviously, it's been around for a long time. There are a lot of victims, so we're just asking for a little bit of time to give them the opportunity to make those decisions. And so if Your Honor is available next Thursday, I think that'd work best for everybody.
Thursday's not an option. There are too many matters that are already set, and I may have 5Es docket in here. We can do it Friday in the afternoon if you would like, which is the 9th of January. We could also,
Judge, I can do Friday afternoon if Mr. Freeberg can.
I was going to say
Yeah.
January 12 is also an option in the afternoon.
I'm not available then, but I certainly could do the 9th in the afternoon.
9th, sorry. The 9th works.
How many witnesses do you expect to want to testify?
It could be as many as 3. I don't think they'll testify, but they may address the court.
Do you expect witnesses on behalf of your client?
We will be submitting letters. Some 1 or 2 people may speak on his behalf. It won't be very lengthy.
Given the range here, are there materials that you believe I should review that are already contained in the court's file in advance of sentencing?
No. Only the sentencing character letters we would submit ahead of time.
Has there been a PSI prepared in any other cases out of county or other Denver County cases?
They may have been. Those would have been quite a while ago, however. So I actually don't know whether there are existing PSI cases for those or not. Or PSI reports, I'm sorry for those cases.
I'm sure there probably are, but I agree with Mr. Pello. They'd be pretty old.
I'll say this, I'm happy to read whatever you submit. The chances of me giving it more careful consideration increase the sooner you submit them in advance of the 9th, for what that's worth. But I'm happy to read whatever you submit. Let's do sentencing. PSIs waived by both parties Friday, January 9, 2026 at 1:30. Let me just take a look at one other thing here.
Can we do 2:30?
I was just looking at what else is set that afternoon to perhaps give you some more certainty. There is another attempt murder matter set for sentencing at 1:30. Does it make sense to set this at 3?
That's
Perhaps.
fine. That's great.
So your witnesses, and you don't have to sit around quite as much.
Okay.
Mr. Friedberg, Ms. Horton.
It's fine.
Set this for 3 p.m. Friday, January 9, 2026. No PSI. What else?
Okay. I have to know what he did to almost kill 10 people. Friday, I will get his sentencing on Friday, and we'll see it Saturday morning.
That's all, Your Honor.
The trial set to begin on January 20th is vacated. We'll notify the jury commissioner that we do not need those jurors.
You know what? I might as well get the other attempted murder case that's right before it, too.
Thank you very much. See you next week. Yes.
An interview was to get her basically what happened, what was the status of the relationship. And if you listen to that, which I'm sure the court has, I was absolutely asking her, I don't know that you know everything that's going on here, and he may be trying to influence what you think. It is based on the fact that those jail calls, Your Honor, that he's talking about, that I was monitoring for purposes of his romantic life, which is insanity. I have broken down, if he wants, he has jail calls to Miss Collins. There are 28 jail calls to her in a 17-day period from April 21 to May 19th.
First off, woman. First off, lady. It's okay if your romantic life is insane, right? She said that like it's a bad thing. His romantic life, which is insane. Isn't it supposed to be insane?
Mr. Cameron has all these calls. I just separated them. I've listened to every single one of those calls. And that's why the conversation went the way it is. In most of those calls, especially in the beginning, Miss Collins says to him, why did you open the door? You didn't need to open the door. You shouldn't have opened the door. And he consistently says, it's not my fault. It's not my fault. You got to blame your mother. You got to blame your brother. There's 28 of these calls. I can give Mr. Cameron, if he wants me to separate them for him, those calls that I was trying to address, that I was listening to. Now, I have not filed BOP when I know I can, because I'm trying for judicial economy in a very serious trial to keep it, not pile on against this defendant. And in my personal opinion, I'm not sure it reaches witness tampering, but is certainly violation of MPO calls that had me concerned when I talked to the victim. He is actively trying to convince her that it was not his fault, and it worked, because when she talked to me on May 21 or whenever that was, she said it's not his fault. So I was doing exactly what a prosecutor should do, telling Miss Collins the truth. is not witness tampering. And I, again, have laid all this out in the argument to the court. If you would like me to address something in particular, Your Honor, I am happy to do that.
Let's start with Exhibit 1 that was attached to the people's response. I have not listened to that recording for two reasons. One, I don't have it. And two, what is the defense's position on me listening to Exhibit 1?
Judge, I'm sorry, when you say you don't have it, you
No,
didn't get it?
this is the next case. This is a different judge, different guy. The other case where he tried to unalive 10 people, his sentence is on Friday. So we have to wait until Friday to find out what's going on. It's just attempted murder, okay? Attempted. And there's another attempted murder right before him that's getting sentenced. So I'm just going to get both of them on Friday. This is another guy.
I gave it to the court clerks before Christmas on the 16th. Did you not? You didn't get it?
Hasn't found its way to me.
Okay. Sorry about that.
Right.
I made sure it was before the holidays.
Which I appreciate. I wasn't going to listen to it
Okay.
without hearing Mr. Cameron's position on me listening to it.
Your Honor, Mr. Benson and I have no opposition to the court listening, provided, of course, that it doesn't carry any evidentiary value in the case itself.
All right. I'm sure it's back there somewhere. I'll find it. Any brief reply, Mr. Cameron?
You are never wrong. Never. I farted in an elevator once and accused you, Salty.
Do you have any brief reply, Mr. Cameron?
No, Your Honor.
Thank you. I will take that December 11, 2025 motion for disqualification under advisement, issue something in writing in due course. Talk about 404B. People filed a notice of 404B on November 17, 2025 with 3 attachments. Any further record there?
Yes, Your Honor. I want to state that it's not a propensity motion. This is a context, intent, and self-defense rebuttal motion. Exactly the type of motion and evidence that the General Assembly contemplated when it enacted 186801.5. The case is not about a single spontaneous shooting. It's about an escalating domestic violence pattern where the defendant uses control, threats, and firearms whenever the victim's family intervenes. The prior incidents show how the defendant responds when family members interfere in his relationship and explains why he did what he did in this case. The jury will be asked to decide whether the defendant, 1, acted after deliberation, intended to kill or securely or seriously injure, and was not acting in self-defense, heat of passion, or mistake. Without the prior act evidence, the jury is left with a false narrative. This was a one-off panicked response to 2 men that he happens to know knocking on a door. The narrative is demonstratively untrue. In 2023, involving the same intimate partner, Ms. Collins, the defendant assaulted her. When her mother intervened, he pointed a gun at her and said, "Bitch, you're gonna die." In 2025, after another domestic violence incident, family intervenes, again, the victim's mother and now her brothers, and the defendant says to the victim, "Tell them to leave or it's gonna get bad." He opens the door and fires, striking one brother multiple times. It's an escalation of the 2023 act. This is not a coincidence. This is modus operandi. The SPOTO analysis is clear on this. It's material fact, it's intent, deliberation, and absence of self-defense are central elements. The evidence shows a specific tendency that when family interferes in the abuse, the defendant escalates to firearm threats and violence. This is the precise reasoning approved in Douglas and Wilner. It expressly is distinguished from Newsom. The inference is not he's violent, so he did it. The inference is this defendant uses guns to assert control when family intervenes. The evidence is highly probative, and any prejudice that flows from it is from its truth, not its unfairness. Eliminating instruction cures any concern. The General Assembly has recognized that domestic violence is cyclical, escalatory, and frequently minimized or recanted. Exactly what has occurred here. The victim initially cooperated, then recanted, cut off her family, and advocated for the defendant. The statute anticipates this pattern and directs courts to admit evidence of prior acts so juries can properly assess intent, credibility, and defenses. Defense's objections, I'm sure, are going to be in the realm of this is too prejudicial. But this involves the same victim, the same type of weapon, the same trigger, which is family interference. He's going to argue it's propensity evidence. Colorado appellate courts repeatedly reject that argument in domestic violence cases when the evidence explains intent and pattern. He's going to argue most likely the prior case was dismissed. Dismissal due to victim non-cooperation is precisely why 18.6.8015 exists. The people need only meet a preponderance standard, which is satisfied through officers, body-worn camera, and independent witnesses. Judge, this evidence does not invite speculation. It actually prevents it. It allows the jury to understand why the defendant armed himself, why he escalated, why this is not fear or accident, and why self-defense does not fit the facts. Based on everything, this evidence is exactly what is contemplated in 404B in domestic violence cases, and the people respectfully request that the court admit that evidence at trial.
Thank you, Mr. Cameron.
Your Honor, I'd like to begin by making it clear that the evidence that the people are seeking to introduce is evidence from a dismissed Adams County case number 23 CR 3735. We are asking the court to exclude this evidence entirely. The prosecution is attempting to introduce a dismissed case involving allegations that were never proven in court, Your Honor. To admit this requires the court to authorize essentially a trial within a trial. My expectation is that that will confuse the jury and simultaneously prejudice my client. The court is instructed to undertake a SPOTO analysis, as I'm sure the court is aware when presented with a request of this type. Defense is going to submit that this evidence is going to fail on two critical fronts under prong 3, which is the independent relevance prong, and under prong 4, which is the prejudice prong, Your Honor. Regarding the evidence itself, what they are actually offering, the people claim the prior act is, and this is verbatim from their notice, amazingly similar to the current charges. That is simply not true. The prior allegation involves a verbal threat. The current case involves the actual discharge of a firearm. The only link is the presence of a handgun. That is a generic description that fits millions of lawful firearms, Your Honor. It is not a signature. It is not a unique modus operandi. Under SPOTO, prong 3, the propensity trap, Your Honor, this evidence fails because the law requires that the relevance of this evidence must exist independent of the inference that Mr. Benson has a bad character. The prosecution argues, and I'm quoting their notice, that this shows a specific tendency to threaten family members when they interfere. Your Honor, that argument is a confusion of error. To get from he threatened a mom in 2023 to he intended to kill a brother in 2025, the jury must accept the intermediate inference that Mr. Benson is the type of person who reacts violently to family interference. That inference that he is the type of person who has this character is the textbook definition of propensity. The prosecution cites Newsom versus People to support their argument, but Newsom explicitly warns against this. In Newsom, the Supreme Court held that a general tendency to be aggressive or a bully is not admissible. That is exactly what the people are offering here, a claim that Mr. Benson has a general tendency to be angry when families get involved. That is character evidence, plain and simple. Rule 404B forbids it. Under prong 4, I mentioned the mini trial concern. Even if there were some marginal relevance, Rule 403 is going to exclude this evidence. The Adams County case was dismissed. The prosecution has to prove that incident happened during this homicide trial. We will have to pause the trial on the shooting to litigate a misdemeanor assault from 2 years ago. We will have to call witnesses to testify about who said what in 2023. The prosecution also intends to introduce allegations of strangulation from that prior case. Strangulation is a highly inflammatory allegation. It triggers a visceral emotional response, Your Honor. If the jury hears strangulation, they will convict Mr. Benson because they think he is a wife beater, not because the state proved the liberation in the current shooting. This is the exact danger that Rule 403 exists to prevent, a decision made on an improper emotional basis. Your Honor, the state is trying to bootstrap a dismissed, factually distinct case to shore up their proof of intent. It requires the jury to make the forbidden inference of bad character, and it creates a prejudicial sideshow that's going to certainly distract from the actual facts of April 16th, 2025. We ask the court to deny the people's request and exclude the Adams County evidence. Thank you.
Any brief reply?
No, Your Honor.
Thank you. That motion, the November 17, 2025 notice of 404B will stand submitted. I will issue written order in due course. What else can we talk about today?
Nothing from the prosecution, Your Honor.
Nothing further from defense, Your
We
Honor.
need to set pretrial conference. How is March 19 at 1:30?
That's another one I'm keeping my eye on. See if she can get the prior one in or not. I don't
That works
know.
for the people.
Thursday.
Your Honor, I'm scheduled to be in a trial.
I'm going to keep my eye on that one. I don't know, guys. I don't know. The case was dismissed. It was dismissed, like she clearly said, because he talked her out of charges. And there's laws around that now that the victim, you know, the prosecutor can go forward even when the victim isn't cooperating. But that case was dismissed. But it's the same pattern, so the judge might let it in. I don't know. What do you think? You think the judge is going to let that in? Jim, you missed it yesterday, I think. I was thinking about you because we had a couple that were sent straight to jail, and you weren't here. I don't know if they're going to let it in. I just don't know. I just don't know because the case was dismissed. So it wasn't really a crime. But maybe if she is just showing a pattern and not for facts, I don't know, probably without prejudice. They can probably they can go after him again for that. Probably. Because it was the victim that said, no, I'm not going forward. So they didn't have any testimony. So yeah, that's without prejudice. All right, guys, we made it to the end. I'm sorry for the technical difficulties. When my cord came loose downstairs and I went back on Ethernet, my streaming software stayed on wireless. So it looked to me like everything was fine. I was connected fine, but behind the scenes, my streaming software didn't flip over. So I had to take care of that, and I fixed it way too late. I realized way too late. But, all right, time for OJ. I will see you all in a few minutes, or I will see you tomorrow. I hope that you guys have a great day. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.